I'll resume the stream hearing. Thank you. Day 2. We're going to break a discussion with you to hear the Goldwater. So, welcome to Goldwater, which your evidence in chief and your supplementary / rebuttal evidence, which we've read. Is there anything you particularly want to draw to our attention before we ask you some questions about it?
Comes to mind?
Yeah, the other preliminary thing I should tell you is that commissioners have it in mind, if the sun's still shining at the end of the day, which today's experience is a big if, we're going to turtle at the end of today's proceedings, we're going to turtle over to Lyall Bay and have a look at both Lyall Bay Beach and Off Point Beach, since they seem to be the only moment, at least the only SNAs whose boundaries are an issue. Obviously, panel's pretty familiar with them. Like, I've walked my dog many times up that ramp at the western end of Lyall Bay, but see what we can see. So, like with tradition, Mr. Dash, do you have any questions of Mr. Goldwater?
Good morning, Mr. Goldwater. Obviously, the whole topic of Indigenous biodiversity has come to a fairly sharp focus recently. Obviously, with the new MPSIB and the work that's been done. And as the chair mentioned, it really, in terms of the identification and the boundaries of the SNAs, it only appears that there is the one area, in which the chair referred to, being at Lyall Bay and Mara Point, which seemed to be a contention about the specific ecological classification and the reasons why. Be helpful for us if you could actually crystallise the reasons why. And the area I'm possibly more interested in is the area to the east, the Mara Point Beach. I'm pretty familiar with that area as well, and obviously there is something of a tension in between where the airport is.
Yes.
And the airport wishes to carry out some works in the future to protect its infrastructure, I understand. Could you crystallise the real reasons why it needs to be as far west as it is? Because we have evidence that it really doesn't cut the mustard, if you like, the entire area in terms of qualifications for it to be an SNA.
Sure. I'll just quickly start with Lyall Bay first, because I think that's important to cover as well. So the eastern end of Lyall Bay is different in its nature to the rest of the beach. It's eroded, and it's characterised by rocks and boulders and the like. The submitter wanted to remove that because it didn't meet the SNA criteria, but we've since found several records of little blue penguin at that site, mainly dead birds that have been probably killed by dogs. And one of those observations saw the dead bird like meters away from a burrow. So there's evidence of that species nesting at that site. And if there's a breeding population there, then that would check the rarity criterion. So that's why we were reluctant to remove that particular part of the polygon from the SNA. Mara Point is it's a similar it's a similar kind of situation. We're dealing with a threatened species and nationally at-risk declining species, banded dotterel. Again, there's been quite a few observations of the species, numerous birds, up to 12, I believe, at that western end of the site. And I know birds have been also observed outside the SNA, closer to the runway. Our feeling is that they utilise that area just outside the current SNA, but also within. And there's been observations of breeding there too, like young chicks. So again, that's probably quite a locally important habitat for that particular species.
Well, obviously, Dr. Anderson takes a contrary view, and we'll hear from him tomorrow on that. I think the airport submissions are very much focused on the, regionally, if not nationally significant infrastructure. It's in proximity. The area has been highly modified in the past and continues to be highly modified.
No, I agree with that.
And the material that's on the beach itself is a mixture of
Hard
what's
fill,
natural, and then there's hard fill and so forth. So the real reason for the classification as an SNA comes down purely to it's a roosting or breeding habitat for Kororo.
Banded
dotterel on the other side.
But I'd say Kororo would be present there too, given they're right throughout that bay.
Yeah. So our role is really just to look at whether the SNA meets the criteria.
Yep.
In terms of the NPSIB. Yep. It's not to actually look in the future about what the airport may wish to do in terms of ecological mitigation. But if we had such an application in front of us, what would be the key matters that would need to be covered in the ecological assessment to be able to determine that it meets the criteria for approval under the Act in terms of ecology?
Well, say for instance, for little blue penguin, you'd need to determine 100% if they're actually nesting there, and you'd take, if they were, you would take actions to move those nests. This is happening along the shoreline, along the highway to the hut. They're creating new habitats. They're moving burrows. It's happened in Auckland too recently with the marina. So those kind of mitigation measures would be put in place. With banded dotterel, it's a bit more fluid because they tend to nest in anywhere on the ground, just in scrapes rather than burrows. So you'd ideally do any works outside the breeding season, and you would look to restore or enhance other part of the SNA, like in terms of predator control or perhaps enhancing habitat to improve the breeding success or opportunities outside of the works area.
You mentioned that there've been some observed fatalities of little blue penguins,
Yes.
and that was mainly from dogs. Was your observation?
Yes,
likelihood. Can we control dogs?
I'd love to see dogs or on leash on Lyell Bay, and I was. Have you got something to say?
Well, it's right next door to the dog exercise area, isn't it?
Yeah.
So there is that tension. Do you know if the council have actually, in terms of the stewardship of the beach area, have they looked at possible additional bylaw controls or as complementary measures to protect that habitat?
Not yet, as I understand, but I was actually talking to my council colleagues the other day about this. It would make sense, given that there's always a conflict between penguins and dogs. It seems in more urban beaches. Every these observations were from iNaturalist, which is a citizen science database, and pretty much some of the birds were sent off for necropsy, and they came back, yes, as puncture marks that fit with dog bites. I think 4 or 5 of them could be confirmed for dog fatalities, which I think is entirely avoidable if there was a bylaw put in.
So
if there was a what? Put in?
A bylaw, or for on leash, and also some signage would be really useful. Just educating people, creating awareness.
yeah, there is pockets of signage all the way around that coast which indicate the presence of certainly little blue penguins, certainly crossing the road, and just to have that whole awareness. So that would assist. Okay, well, we'll hear from Dr. Anderson. I think his major concerns are, from my reading of his evidence, particularly at the Mile Point site, is the extent of the SNA. Well, in terms of natural features and so forth, it's highly modified boulders. It's next door to a modified seawall, and I understand the proposal from the evidence of the airport is that they are wishing to do reasonably substantial works, and to do reasonably substantial works, you need a bit of land for sit down and lay out areas and so forth to actually do that. So, all right, thank you for that. My next question is more at the bigger picture level. It's more in terms of the NPSIB criteria about managing Indigenous biodiversity outside of the SNAs.
Mm-hmm.
And presumably you've had a look at the evidence of Dr. Norman as well, the economic evidence as well?
Yes, I've skimmed through that. Yes.
And just from a big picture ecologist point of view, did you have any observations in terms of his findings, particularly in terms of the overall Indigenous biodiversity benefit that such measures like 100 square metres on a urban or residential site, and 3,000 in the rural area, about the practicality and workability from an ecologist point of view of those numbers? I think you've settled on agreeing with 100 square metres.
Yeah, that's correct.
Because there is an obvious tension, and we heard yesterday a considerable part of the day was trying to get our head around the National Policy Statement for Urban Development, which basically, encourages larger amounts of intensification in the urban area, vis-a-vis a residentially zoned site, for example, which has got a bit of bush on it. Now, in terms of that sweet spot, 100 square metres, my understanding of that is it's about the footprint of a 3-bedroom house. Okay, in terms of being able to remove that 100 square metres, is the emphasis on retaining the best of what is left, or is there a whole management approach in terms of how somebody would assess a resource consent when these things come in? Because there's vast amounts of areas within the city which have some bush of whatever description on them. So I'm trying to work through the efficacy of the real push for urban development, appropriately zoned sites, otherwise permitted, versus the ecological benefits there would be in terms of retaining that bush. So do you have any overall comments on why, how to resolve that tension?
Yeah, sure, I can provide some comments. I mean, I guess the first thing to point out is that 100 metres has gone up from 50 square metres. 50 square metres.
Well, I think the 50 square metres is what the resource consent team have been using in practice.
Yeah.
Rather than being anything codified in the plan, is what they should. It's what they should do. Is my understanding of it.
Yes. So when it comes to the 100 square metres, the emphasis would be on clearing lower quality vegetation on within a property, and preferably vegetation that isn't contiguous with say more mature, high quality vegetation. So I guess you're not creating new edges or fragmentation.
Have you considered the practicality from with an ecologist lens on it of being able to do that? You've got a relatively small site. It's half covered in bush. It's often in the Wellington context on a considerable slope. To actually be able to get this figure of maximum amount of that you can actually remove as of right, while still getting the access in, the earthworks required to put the building platform in, and having reasonable areas around the dwelling itself which aren't shaded, which is also a very big issue in Wellington, particularly some of the more southerly aspect. The areas which haven't been preferable for residential development in before because they have constraints, either slope, they've got bush on them, they're hard to get at. So I'm trying to work out whether this 100 square meters is just something which is an ideal number, or could it be more, or could it be less, or is it actually required at all? Because we're being told by other submitters that you don't, if it's a residentially zoned property, you should be able to maximise them in accordance with the bulk and location rules.
Well, I think you've characterised it very well about in terms of topography and other physical constraints. So yeah, my thinking is that 100 square meters is probably not going to be appropriate for quite a few of those 13 or 100 or so properties, but there has to be some happy medium. Like for instance, in Auckland, it's 300 square meters within an SEA as a controlled activity, regardless of the type, whether you've got kauri forest or weeds on there. So
it's 3 times the 100 square meters, isn't it?
Yeah. So
it is much more permissive than what's being proposed here.
So it's quite good to contrast it with that.
Yeah.
But if you go below 100 meters, what can you actually do with that as a landowner? You could put a shed there, but for a minor dwelling, it's trying to find that sweet spot, I suppose, but within the constraints of Wellington's topography and existing forest cover.
So come from a situation in Wellington where there was no what we call blanket vegetation rules that permits vegetation removal. You could do it on your site unless it was particularly categorised as having very significant ecological values or there were notable trees on it, to a situation where there's an additional consent requirement every time there is a proposal which removes more than 100 square meters of bush. The questions I have is that those individual sites, have they been ground truthed to make sure that those on an individual site or collectively with other bush on other sites, I use bush in the general term, has there been any ground truthing that they would actually meet the criteria on an individual basis? I realise you've done the work for those at SNAs, but those are outside of SNAs. Has the level of ground truthing been done to be actually to give us sufficient comfort that the regulation proposed is right, it's at the right level, and it deals with the right effects?
I'm not sure if that ground truthing has been done. Possibly I might defer to my colleague about that.
Thank you. So that's all been done on the basis of aerial imagery. Rather than getting your boots on and climbing up the hill to have a poke around to see what is actually in that particular piece of bush.
Yeah, as I understand.
We're also got to look at the general thrust of the legislation to reduce transaction costs, reduce the amount of effort that is required as well. Do you feel that if there was going to be a figure, whatever that figure might be, that it should be accompanied by streamlined guidance about what needs to be submitted? Because if you've got to do an ecological assessment, and depending on the scale of it, but you could be 5,000, that sort of, or more, very likely be less, and then you've got the council process costs on top of that, and then if you've got a planner who needs to pull together the application as well, so you could be for wanting to put in one additional house, you could be looking at an additional transaction cost of 10,000 as a figure, but it is a reasonable amount. Is there a way in which there could be a simplification or a streamlining of the information requirements that could assist or reduce the burden? And this is in the context that the urban areas, there's very permissive general rules relating to building development in the urban areas. Is there any way to reduce the transaction costs?
Possibly if you put in like height thresholds for the vegetation that's being cleared. So
anything less than 1.5 meters or something like that.
Yeah, or possibly 3 meters or 4 meters or something like that, which has been used in other districts. I think Upper Hutt City Council, District Council used that. Well, that would be quite a good test, and then that excludes sort of younger vegetation or possibly exotic vegetation.
Yeah. I'm thinking about what we call the Johnsonville Line corridor, the suburbs, Baystown, Naya, Kandala, and so forth. The general setting for those areas is, and you can see it from the views of the valley. It's the first impression is the amount of green that there is in those areas there. And conversely, there's a council decision to say that basically go for it. Yeah. Six-story development, and prior to the NPSIB, which was when the plan was notified, with no restrictions on vegetation, or vegetation clearance. So there is a clear impact likely from that particular tension. So I think I certainly know where you're coming from. The Indigenous biodiversity is important, but where is the happy medium being able to develop, but also to be able to retain those pockets? And presumably, those pockets are, the bigger it is, the better it is.
Yeah. I mean, I wouldn't want to see mature forest being cut down within the 100 square meters.
Okay.
Absolutely. And I know a lot of those hills are covered in good quality mature forest.
But there must be large patches that haven't been assessed before for possible qualification to be an SNA as well as a result.
That's right, but you could probably extrapolate to some extent from contiguous SNAs what that vegetation is like.
Excuse me, Commissioner, can I just follow up? There is a wrinkle here that outside SNAs we can't have rules protecting trees, specifically identified. So if you had a 3 to 4 metre height limit that didn't apply to trees,
Yeah.
what would it apply to?
Yes,
I was trying to envisage something that's not a tree that would be that high.
I was thinking average canopy height, but yeah, it's a good point.
So that might. So that's a wrinkled.
It is.
That is,
It's-
yeah.
And I have thought about that before, and it's a bit of a disconnect.
I think Mr. McCutcheon yesterday was very candid in his views of the challenges there are with navigating the various legislative instruments which are in play at the moment. So, and you know, and I think we all feel that this is very challenging in terms of that. Probably my last question is the, you know, the general urban bush cover in Wellington, is that different in terms of its makeup and its characteristics to other urban areas in New Zealand?
Yeah, it's quite a broad question, but yeah, generally you don't find so much bush cover right in the middle of the city. So it is quite unusual in that respect. I mean, you look at places like Christchurch, where within the city there's virtually no indigenous cover.
Quite a few urban exotics in Christchurch, though.
Yeah. And Auckland, you've got it's more of a patchwork throughout the city. Then you've got extensive areas in the Waitakares and Hunuas outside of the city. So so yeah, the only other city that springs to mind is probably Whangarei, which has a lot of bush right actually within the city. But
Okay, well, thank you for that. That's on to my colleagues.
thank you, Commissioner.
Following up on that question, that answer, you said that Auckland has a rule of 300 square metres outside SEAs.
Oh, sorry, that's a controlled activity of clearance within SEAs.
Oh, within SEAs.
Within SEAs, yes.
What rule? Gotcha.
I was just trying to highlight that as what was basically permitted or consentable in terms of maximum clearance.
Now, if that wouldn't pass muster under the NPSIB.
Yeah, I don't know how they're going to resolve that.
Yeah, well, well, I think we've got enough problems sorting out Wellington without worrying about how Auckland will sort itself out.
Commissioner, I'll just say that the applicant is still required to offset any residual effects. So it's not like you can go and chop down your Purakawa forest and not do anything about it. Although controlled activities are always going to be consented, there's still, if there's a net loss on that property, you will go and have to do something elsewhere.
Yeah, gotcha.
In terms of offsetting. So it does meet the objective of the NPSIB.
And as you say, that the prevalence of urban bush in Wellington is not unique, but unusual, certainly among the larger cities. That in terms of the detail of 100, you said 100 metres was, I hesitate to say it was,
yeah,
but you got to put a line somewhere, and any sort of number like that, you're always susceptible of being chipped about why isn't it 95 or 105. But we had a discussion yesterday with Mr. McCutcheon about well, is this a oncer? Is this for the life of the plan or the life of the property? Is this per annum? And his concern about there are rules and other plans that are, or Forest and Bird suggested 200 square metres per annum. And the problem is, well, how do you enforce that? Is it a rolling 12 months and those kind of things? And how did you actually know what was there exactly 12 months ago compared to what there is now? So yes, there are some challenges with that process. But what's your view? Like when you recommended 100 metres, is this 100 metres for all time?
Yes, I'd say so. I mean, when you look at the size of the properties you're dealing with, it wouldn't take long to clear the whole property if it was consecutive years. So, yeah, for residential areas, I would have thought it would be a one-off. Whereas in rural open space areas, we've got up to 3,000 square metres. That could be over a longer time. Say maybe every 5 to 10 years. Given there's evidence of a lot of regeneration happening in those areas. So, but yeah, definitely just a one-off in residential areas.
And sort of in paragraph 31 of your evidence in chief, you talk about practical exemptions permit essential activities, power lines, sight lines, roadside vegetation, tracks. We had a discussion yesterday about fire prevention. And I'm conscious that FENS recommends, I understand, a 10 metre clearance of flammable vegetation. And what's your recommendation as to how to balance that conundrum?
Yeah, so when I was doing some work for Porirua City Council, we were dealing with that rule in their district plan, and a lot of the properties were surrounded by kānuka, so that's a flammable species. So that 10 metre rule was, I think, added. It's quite a different context in Wellington City. We're dealing with more broadleaf species like mahoe, tawa, koe, which are far less flammable. So 10 metres may be too much, and it might result in actually too much clearance. So and I guess you've got to weigh that up too with things like shading as well, and avoiding dampness and things like that. So 5 metres would probably be more appropriate in the city's context.
Thank you. Question about identifying SNAs, and we discussed this yesterday. For you as an ecologist undertaking that identification role, to what extent do you take into account the fact that a landowner might have an existing resource consent to clear an area, or a certificate of compliance, which the Act says is to be treated as a resource consent? How do you treat that? Do you say, well, that's something for the planners to worry about? You're just there to assess the quality of the vegetation, or do you, or does it factor into your decision making process?
I think you answered in point A. Yes, it's a planning issue. We've dealt with that again in Porirua, where actually, yes, the landowner had a certificate of compliance, I think it's called, to remove quite a lot of an SNA. But yeah, as an ecologist, it's really just looking at those criteria and does that piece of vegetation meet that, regardless of any other planning instruments or things that might be imposed on that property.
Thank you. And we also had a discussion yesterday in the light of the legislative provisions about clearing trees. What's a tree?
Well, yeah, I had a bit of a chuckle looking at those definitions. And when we're doing surveys, we for vegetation, we separate vegetation into things like forest and scrub and shrubland. Typically, shrubland is low stature, regenerating or small stature plants that don't have a closed canopy. Scrub will be taller vegetation, like might be made up of mahoe, manuka. They'll form a closed canopy, but they'll have a diameter of less than 10 centimetres. And typically, we call forest vegetation with a closed canopy that is predominantly made up with stems of more than 10 centimetres at 1.4 metres off the ground at or breast height. There's probably, some people may argue, no, a tree's got to be like 15 to 20 centimetres diameter, but for the purposes of ecological surveys, it's usually anything over 10 centimetres when measured at 1.4 metres off the ground.
So that would be your test.
And I'd also look at the species too. Is it? I mean, because you can have shrub species like a Coprosma, karamu, which may eventually develop into a small tree, but typically, you look at canopy species such as tawa, kohi, species like that.
So couldn't write that down fast enough. You said
right.
It's the starting point was shrubland. How did you describe that?
Yeah, shrubland is low stature plant communities, typically with a fragmented canopy. So you could walk amongst it quite easily. Plenty of light getting down into the understory, and they comprise regenerating species and low stature species. Your hebes and your coprosmas and
a scrub is taller, it can have a canopy, but
usually
the stems will be less than 10 centimeters.
Yeah, think like Kānuka on the hillsides, Porirua, places like that.
And just going. When you talk about the SNAs and an issue, and your sort of counterpoint with Dr. Anderson's evidence, you talk about birds roosting. What does that mean? When you talk about roosting?
Roosting is basically resting, or they could be sleeping, or typically for for birds such as oyster catchers, which might feed at low tide. When the tide comes back in, they can't feed, so they'll go and rest or roost. Often they're called high tide roosting habitats. So it's birds will roost, and they may not be, that may not be where they breed, but there may also be an overlap.
Because the wild case points us to the definition of habitat, which excludes areas where birds are located fleetingly. So how long roosting is for how long? How long do they have to sit before it becomes a habitat? When does it cease to be fleeting?
Yeah, it's a good question. But my response to that in terms of banded dotterel is that birds have been observed there multiple times, and there's evidence of breeding in that general area. So if there's evidence of breeding, then that word fleeting is not applicable. I'm not sure if Dr. Anderson was aware of those records.
We'll ask it.
Yeah.
And I suppose the Lyle Bay, sort of the reason for my amusement in suggesting a bylaw is that my experience walking that beach is that there are dogs every which way.
Yeah.
There would be on any given Saturday morning 10, 20, 30 dogs all running hither and yon out of control.
Yeah, I think even if you could just like somehow protect that eastern end, because penguins aren't going to be nesting up in the dune, so it's pretty unlikely. I think so. Really, and all the observations were right in that smack in that area where those rocks are, where it's eroded. So that's what's attracting them. So dogs could have the run of the rest of the beach as long as they're on leash or maybe excluded from that far.
Yes.
But
I suppose my observation is if there's not a fence.
yeah, I know. It's ecology is as much as a social science.
Yeah. So your key point is that those observations are in the rocks alongside the ramp. There's a concrete ramp down there that goes from solid concrete to rocks, and there's rocks that wrap around the ramp, and that's where the penguins were.
Yes, yeah. They're actually quite close to the dune as well, but they're all within the SNA polygon. They're not continuing around the coast further to the east. I don't know if they're beyond the ramp or not.
Yeah, well,
Adam? Yeah, they're definitely not as west as the dunes, but because they are within their polygon. Yeah. Okay.
Yeah, because we'll go and have a look at it this afternoon, but my recollection is you go from the footpath, there's a ramp down, then it becomes loose rocks.
Yes.
And at the western end of the ramp, western side of the ramp, there are rocks coming up. So there's not actually a dune in that locality.
Yep.
It's all that wraps around the ramp. The rocks wrap around the ramp.
That's right.
And lastly, a question. You go to paragraph 18 of your rebuttal evidence. There's a typo. It's date. Can you give me the correct date so I can write it in?
You're referring to 2016.
Well, yes. Well, is it 2016 or 2015 or something else entirely?
That's an iNaturalist. That's referring to an iNaturalist record.
So it's not a date at all.
No, see that footnote. That's if you put that into your internet, that would come up with the iNaturalist record and a photo of those eggs within the culvert.
Oh, so that.
Yeah. So yeah. Sorry.
So the area is it's missing the footnote. The 5 is the footnote.
Yeah, I can see how that could be construed that we observed the eggs, but but no, that's actually just referring to an observation someone else made.
And it's but it was an observation in 2016.
Yes.
The 5 on the end is supposed to be the footnote.
Yeah. Yeah.
Gotcha.
Sorry, it's pretty
That's that
small
little
pipe.
Maria, did you have anything for Mr. Goldwater?
Just a couple of questions to follow up with you. In relation to your evidence in chief, paragraph 37, that you get that.
Mhm.
And you refer there to the adoption of the 100 square metre contiguous area clearance limit.
Yes.
And that it still obviously has potential and to result in a net loss of Indigenous vegetation in urban areas. But you say that with considerable areas of rural land regeneration,
Yes.
There's likely to be over time a net increase in the extent of Indigenous vegetation. Yep. I'm just wondering what would be required to ensure that there is sufficient certainty to enable the adequate regeneration, if you like, of Indigenous vegetation to achieve that overall Indigenous NPS, Indigenous biodiversity objective of no overall loss.
Yep.
And I'm wondering in particular about the threshold, the permitted activity threshold, for instance, in the rural open zone area of 3,000 square metres, and whether, you know, that could be reduced to some point below that threshold in order to provide greater certainty to meet that objective without undermining the balance in terms of, you know, providing for rural activities in those areas, or some other method. Are there ways of, is there any room or scope there to enhance certainty of achieving that overall objective without upsetting the balance?
Yeah, it's a good question. I think it sort of comes down to a sort of question of confidence. And when I actually did a desktop analysis of some of the rural area SNAs around rural areas, and between 2006 and 2024, and you can see there's been, you know, quite a lot of natural regeneration, you know, around and adjacent to existing SNAs. The same thing is evident in districts like Porirua as well. There's actually a lot of regeneration, and that's probably as a, you know, result of farming not being economic anymore. So I'm reasonably confident that that objective, the NPS, would be met. I've got a couple of photos here that that might be useful too, if you'd like to. Polygons are, and on the back of one of those as well. They're not correct.
So
They are sort of more to the northwest, around I think Makara. I can get the exact locations for you.
If you could give us that.
Yeah.
Or feed through maybe to Mr. McCutcheon, so
Yeah,
that his
absolutely.
reply he can give us like a key location, exact dates, that kind of thing.
Yeah. So yeah, I mean the key thing is you can see ecological processes happening there in terms of regeneration, and a lot of those areas would have started off in gorse too, but have now been superseded by, you know, mahoe, manuka, ponga, species like that.
And so they've got areas are already identified, are they?
Yeah, that's right. So those purple areas of the
purple areas.
SNAs, it's just a reference. So it just shows how dynamic our landscapes are too, and that SNA boundaries, you know, can't be locked in forever, because that's why it's probably appropriate to review them in 10 years, every 10 years.
It's quite instructive though, looking at these photos, see that how the SNA boundaries sort of provide that core, you know, heart of regeneration that occurs on the outskirts.
Yeah, that's exactly it. Yeah, because some of them are like a small gullies, gully
Yes.
floors. The edges have been grazed, but now they've been retired so that they just spread up the slopes, the vegetation.
So you don't have any, I mean, that 3,000 square metre threshold in the rural open zone area.
Yeah.
That's, in your opinion, at the right.
I think so. I mean, when you weigh it up, places like Upper Hutt, which is I think one hectare, I think every 5 years, is that right? Yeah. So that's quite a bit larger. 3,000 seems to be quite conservative, especially in the context of what's happening in that landscape. Oh, right. Yeah. Right. That's right. Yeah. Good point. Thanks.
Thank you. Okay, thank you for that. And just going back to the criteria used for the identification and assessment of SNAs and the reference to policy 23 of the RPS. And I note there that Wildlands have also used, in addition to the criteria that are outlined in the NPS,
Yes.
the additional criteria of the tangata whenua values. And I'm just wondering how those values have been determined and assessed, given that, unlike the other criteria, they're not ecologically based. They would require, I'd imagine, some sort of input from a tikanga or kaupapa Māori perspective in order to be able to accurately determine what they are.
Yep.
So I'm just wanting to get some clarification from you around how that criteria was applied.
I guess it was an informational thing. There were some sites that did have some information on taonga species, or I think recall one site that actually had a grove of karaka trees, which was significant to Māori, and that was mentioned in the assessment. But as far as I'm aware, and my colleague Nairi might want to interject here, that very few sites have had such information, and I guess it was beyond the scope of Wildlands to track that down.
Okay.
Yeah.
So the reference, sorry. So the reference to that criteria, that particular criteria, was more in terms of reflecting what information already exists.
Yes. Yeah.
Okay.
That's right. It wasn't such a deep dive into.
Okay. So it probably hasn't really been applied then. Would you say that criteria has been applied in the identification and assessment of these sites, the SNAs, or it's just?
It's basically in our desktop reviews and any other information. If there was anything that was important to Māori, we of course considered that.
Okay.
Yeah.
And so that sort of ground truthing and tangata whenua consultation and involvement and corroborating and adding to what information might already exist in relation to those sites is yet to occur.
Yeah, I'd say so. But yeah, particularly for the bigger sites.
Yes.
And maybe probably public land. So
Yeah.
there's definitely scope for adding that information.
Okay.
Which I think is a good thing.
Yeah. And presumably we'll come back to our Section 42A officer in due course, but there is, as you're probably aware, a plan change intended for the future to deal with all the outstanding issues in relation to cultural matters that are yet to be properly integrated into the district plan. And so I would assume that this would be on the list to be included in that plan change process.
Yeah. Yes. And yeah, Wellington's, I guess, unique in that way, isn't it? Having that
I think so.
that additional criterion. Yeah.
Those are all my questions. Thank you.
One follow-up from Commissioner's questions. We had some information yesterday from Mr. Norman's analysis about the proportion of Indigenous biodiversity outside previously identified SNAs in the urban areas. What's the what's the position in rural areas? How much of the Indigenous vegetation is within an identified SNA and how much is outside of it?
Yeah, I'll just bring that up. 5,000, yeah, 5,200. Oh, you mean hectares? But, yeah, 5,200 hectares, I think, public land. Rural. Yes, in rural land outside of SNAs, total Indigenous habitat is about 5,900 hectares.
And how much rural land is within the SNA?
There's total area classified as SNA as of 2016, about 1,700 hectares. 3,000 in public land and only 82 in residential, which is
So 1,700 hectares
on rural land.
as it's
That was
16.
Yeah, that was from our report in 2016.
Thanks. Liz?
That was residential. Will you just
Residential was 82, and contrasting that with 555 hectares of Indigenous habitat outside of SNAs, residential, and only 450 hectares outside of SNA on public land.
Sorry, is that in one of your reports, is it?
Yes.
That-
Yeah.
2016 one.
Okay, the
2016,
So we can refer back to that, yeah. Thank you. Just a couple from me. I'm just interested in the iNaturalist database,
Yes.
and you've obviously used that, Mr. Anderson hasn't, but is there a multitude of databases available, and how are they monitored, and why is that one? Or do you just go through them all to figure out if there's been a species there that how does that work?
Yeah, good, very good question. So you've got a range of databases. For instance, we'd often use one called eBird, which has records of bird species all around the country. I'm not sure if do you get specific locations of birds, like in eBird, like iNaturalist? Okay.
Yeah.
Yep. So yeah, that's great. So with iNaturalist, you can actually see the exact point on a map, and you click on that point, and there'll be a photo and a description, and someone else, an expert, would have confirmed that. So it becomes like research level grade.
Right.
And then there's other databases from DOC, with bats and herpetofauna, lizards and frogs and things like that. Again, they'll show exact locations, the date, a description of whether the organism was dead or alive, or breeding, or numbers and things like that.
Yeah.
So, yeah, sure.
Yeah.
It's a systematic survey that's undertaken by the Ornithological Society.
Okay, yeah,
And then also to citizen science.
right. So you have confidence in the data because there is some sort of level of control of the data that goes on there, or
Yeah,
checking.
it gets checked,
Yeah.
or curated.
Curated, yeah.
So on each observation, you'll see the people who have confirmed that ID, and often there's photographs, so there's no dispute.
Yeah,
And some people, will, for instance, with a little blue penguin, take that bird and get it examined at the museum or whatever, at the
Yeah.
vet, to determine the cause of death. So yeah, sometimes you get a lot of detail with these observations.
Mm.
So they're really useful, and we incorporate iNaturalist and those other databases into all our reviews.
thank you. Just one other one from me. Just in relation to Moa Point, Commissioner Daish talked to you about, it being, if you like, a modified area.
Yeah.
I just sort of wondered what sort of weight do you give to a modified area when you're looking at SNA identification?
Yeah, good question. I think it all comes down to, in this case, threatened fauna. They're actually using that modified habitat. Yeah, I agree that there are parts of that SNA that are more natural than others, and where the banded dotterel have been observed, it's probably in a more modified state. So you possibly, if there are no birds there, you'd probably be justified for removing that part of the SNA. There are more representative examples of, say, the gravel dunes and the gravel beach further to the south, further to the east. But threatened species often don't mind whether it's modified or not. So that sort of has to be taken into account as well. Adam?
And multiple workshops and executives.
Right.
A few years ago.
Yeah, thank you. So I know in your rebuttal, just paragraph 23, you say that further investigation may be required to determine the true extent of the naturally occurring shingle at that site. So just from our discussion we've just had, what would be the outcome of that? If you decided that the shingle beach finished there and then it was highly modified.
I don't think it would. It's sort of separate to the threatened species criterion.
Right. It's just a
you might want to just out of
characterization thing.
Just for, I guess, to conclude, peace of mind, you could get a coastal geomorphologist to do that. It's it's just a funny site that's had a lot done to it, but there are still vestiges of its original form. But I just don't think that's the determining factor for the site.
Okay. Thank you. That's all I had. It's helpful.
One of the lines of reasoning that Weil have put to us is that the definition of habitat excludes artificial structures, and they query because this is a reclaimed beach, and whether that means it's a structure. To what extent, if any, did you consider that question?
Well, there's still natural vegetation occurring there. It's not like it's purely concrete and lacking any other kind of habitat. So Yeah, as I said before, I agree that there is some modification, but it's clear that birds are using it as habitat for breeding. So it's obviously fulfilling some purpose. Otherwise, they wouldn't be keep returning to that spot.
I think that the argument is it's the classic. I can understand your puzzlement that classic lawyer suspension of disbelief category. That the legislation directs that what you might consider as an ecologist as a habitat is not to be treated as a habitat if it's a structure.
Yeah.
And so the question for you is, did you consider that, or is that something for the council lawyers and planners to worry about?
We didn't mull over it too much. No, we didn't get into that kind of detail. It was really, we're guided by the presence of those species.
And I had two other follow-up questions which I forgot to ask you earlier, and that's related to firstly Mr. Edmonds' concern about his property in the Rigi, or actually more accurately the reserve in front of his property, where he said, well, there are where the road reserve is characterised as an SNA, and he said, well, there are a whole lot of garages in that road reserve down that road, and so how his characterisation of wildlands check was that nevertheless there's still bush. Basically, it's wrapped all around the garages, and so have you given any thought to, well, how would you treat that? Like, do you say include the garages within the SNAs on the basis of that it's a contiguous area, or do you like do saw teeth because manifestly they're not natural and they're going to stay there?
Yeah, typically we'd key them out. We wouldn't include them. Yeah, it can be a bit fiddly, but we do that with roads too that would go through an SNA, often depending on the size of the road. But yeah, typically structures, if you can see them in an aerial photograph, would normally be excluded, and access ways.
Well, I wonder if I could ask Mr. McCutcheon, between you and Mr. Goldwater, and it's part of the council reply, to have another look at the Rigi and see whether that actually happened, and if not, whether it should happen, to respond to Mr. Edmonds' position. And last point is the definition of late running information, since we received it 4 o'clock yesterday from the regional council, who say that there are a whole lot of beaches that should be additional SNAs, and they say they've provided council with an ecological assessment. Has that permeated through to you, or?
No, just for clarity, I have not briefed Mr. Goldwater on that late piece of evidence, nor the report that was sent at a rather late date.
Yes,
myself.
So we better at least ask the question while Mr. Goldwater. So that's all I had. Any final thoughts, questions from Mr. Goldwater, team? So thank you very much for your input. We appreciate hearing from you.
Thank you.
So, Mr. McCutcheon, I think we're back to you. My note said that we stopped at page 132 of your 42A report. The wanted to work through the suggested amendments to the introduction. On page 134, Mr. McCutcheon. The first is the suggested change to the first paragraph. The purpose of the chapter is to fulfil the requirements under the NPSIB and the NZCPS. Does that need to be qualified to acknowledge the points that are effectively deferred as we sort of something as far as possible or as far as currently practicable, something like that?
I agree, that would be a sensible amendment to make.
Next is the discussing the shifting the focus from the RPS criteria to the NPSIB criteria. And my reading of Wildland's assessment is that effectively there are differences, but they're not material. Putting them alongside each other. Did the assessment go to the next stage of testing? Well, are those differences material in relation to any particular SNA?
So the work which Wildlands undertook to review the extent and the criteria of all SNAs that were notified in the plan under the RPS criteria, and then under the NPSIB criteria, didn't recommend any change to those extents or removing any SNAs, even if there were material impacts or material changes between the descriptions of, say, one of the criteria. Essentially all of the SNAs meet multiple criteria such that it wouldn't be fallible to their inclusion in the schedule in the first place.
Gotcha. The statement, the following paragraph, historic urban land and rural land use activities contributed to continuing decline over time. Does that need to be qualified given the discussion we had yesterday about the more recent upturn?
I agree, that could be phrased more in the past rather than a continuing present.
And further down, and this is just more language, the paragraph that now says that now starts for provisions relating to. There seemed to be a lot of relating going on.
Mm.
And I wondered if you could look at how that's expressed in the 1, 2, 3, 4, 5, 6, 7th paragraph. And lastly, we need an REG reference. I will cover this in the wrap-up hearing, but because this is carve out, you've got a cross-reference to infrastructure in the national grid. Should there also be a cross-reference to the REG chapter?
Yeah, I think there should be, and I hope that in that discussion between Ms. Foster and Ms. Jeffries and Mr. Jeffries in respect to the wrap-up hearing, they bottom out whether we're referring to provisions or rules, and that will be dependent on where they get to with whether there's still a cross-reference to consider some of the policies in the eco chapter in a have regard to sense, whether it's just completely standalone. But I think in principle it should refer to renewable energy generation because
there should be a reference of some kind to
I agree.
to REG here.
Yeah.
As to what exactly it says, that's for the wrap-up hearing.
Yeah.
All right. Anyone else have anything on the introduction?
Just one further question for you in relation to the introduction. And I note the reference to policy 23 of the RPS has been removed for reasons that I do understand. But given that the identification of SNAs in this case actually goes slightly beyond the requirements, if you like, of the NPS IB, and including that additional criteria for tangata whenua values under policy 23, and that policy 23, I guess, does underpin the method used for the identification of SNAs in this case. I'm just wondering, in that context, do you think that there should be a reference in the introduction to policy 23 of the RPS?
Yeah, I think given the discussion that we've had today, I don't think it would be inconsistent to retain that reference.
Yes,
It wouldn't.
I was going to ask you that.
Yeah.
You think it would say something like originally identified and then cross-checked against? That would, because effectively the legal process, the legal obligation to give effect to both would suggest that if any would be identified or as Commissioner says, characteristics highlighted under the RPS that wouldn't be highlighted under the it's the greater of the combination rather than the lesser.
Yeah, I agree.
Gotcha.
Thank you.
Going on to the objectives. The paragraph 4.445 to analyze submissions seeking additional reference to the coastal environment, saying, well, it's not reducing the level of protection afforded by WSNAs in the coastal environment. I wondered about whether the relief doc sought was actually seeking, was actually implying that, or whether it was just adding a helpful clarification saying that, making it clear that SNAs include, the identified SNAs include SNAs within the coastal environment. It's not suggesting that the outcome is different. It's just a clarification whether that would add value.
Yeah, I can see that a reference could be added to say significant natural areas, including those in the coastal environment or coastal significant natural areas, would be, would help with clarity, and address the submitter's concerns that they are identified in the plan.
And the other aspect of doc submission, seeking reference to rehabilitation. Is there a difference between restoration and rehabilitation? And if so, what is it?
So the NPSIB contains a definition of restoration, which means the active intervention and management of modified or degraded habitats, ecosystem landforms and landscapes to reinstate indigenous natural character, ecological and physical processes and cultural and visual qualities, and may include enhancement activities. I would be surprised if that were in conflict with a definition of rehabilitation. So to summarize, I would see rehabilitation as including or within the definition of restoration. Drawing on those concepts of active intervention to do something different to improve an outcome that would be consistent with a plain English definition of rehabilitation, in my view.
Right. So my next question is up to the discussion of P2. This may be overtaken. But get the policy in front of me. Just give me a second. This is an aspect of the question I asked you last night. Should we take out the references to infrastructure? So there's safe operation of lawfully established roads or rail corridors.
I agree. This policy and the rule, which we discussed yesterday, should only be in relation to those forms of access that aren't addressed under the definition of infrastructure and otherwise captured through the INF Eco chapter.
So that might be something. Check these.
Yeah.
And in relation to wherever it's sitting, are these actual roads or paper roads? Or, like in this context,
Mm.
should it just be actual physical roads? Should the focus be on anything with the legal status of a road?
I think it's the latter, for reasons of certainty, that road legally or lawfully exists, even if it hasn't been physically constructed and vegetation cleared to enable it to function as such.
And if that's your definition, do you need to worry about whether it's lawfully established? Because a road, a paper road, it either exists or it doesn't.
I also was thinking last night around the rejection of the use of the word existing and whether that actually would be in greater alignment with the thrust of clause 3.15, which is established activities. Keeping it more general might address that problem.
Where does that line of thinking take you? As you say, more general is good. It's particularly in an objective sense. What sort of wording do you think that would result in? Like, I don't want to pin you down because you'll have the opportunity to think about it and tell us exactly what you think in reply, but just give us a sense of what you're thinking at the moment.
I guess more fundamentally, if we're trying to exclude infrastructure per the definition of in the plan, which is consistent with the specified infrastructure approach, it could even potentially just say safe operation of tracks, access or private tracks, roads and access ways.
Suppose that's the opposite of being general, of course. I'm not saying it's wrong, but if you're looking for something more general, that doesn't quite seem to do it. So as I think the request would be, keep thinking about it. I'm not saying that's shouldn't land there. If you think the question is there a better way to express it? There may not be. Like I can't think of one on the fly. The discussion of protection and restoration incentives, what was policy 4? Yeah, of course. Yeah.
Jump back a bit. Just a clarification. Your paragraph 497, you're talking about P5. And I just noticed in your appendix A, the references to policies are different. Now, I realize it's probably because of the renumbering, but I just wanted to check because what's in your 42 is different to what's in appendix A. Just the reference to
Yes,
the policies
yeah.
in the first.
Mm.
I just wanted to check which we should be relying on.
So it's the Appendix A version is correct, and that first line should say manage any activities of use and development on SNAs that are not referred to in Eco P3.
Yeah.
Or that are specified activities in Eco P4.
P4. Okay. Thank you.
Apologies.
Just a further clarification from me, going back to 467, and it's just in relation to the reference there to 004, and your preference to delete that objective in its entirety, on the basis that the intent's already covered in 03. But that doesn't seem to, again, marry up with the objectives as they are now numbered, I think, where eco now becomes 5, and that relates to significant natural areas that are maintained or restored by mana whenua, and the 3 becomes 4, and that's SNAs that protect from adverse effects from forestry, so that one would be applicable, presumably. Can you just clarify that?
Certainly. So 467, for increased clarity, should say, my preferred outcome for which I have no submission scope is to delete notified Eco 04, which is the objective in respect of plantation forestry in its entirety, on the basis that its intent is already covered by renumbered Eco 03, which would be that general objective in respect of protecting SNAs, including those in the coastal environment.
you.
Yeah, sorry about that. Lots of renumbering.
Yeah, absolutely. I know it's really difficult. It's just that I thought I was going a bit mad. Thank you.
And, gotcha. And the fact that you have no scope is why there is still what is now numbered.
Correct.
I can have a break for a cup of tea at this point. So we'll be back at 10 to 11. We'll restart the hearing. McCutcheon, before I forget it again, just to interrupt our dialogue working through your 42A, Greater Wellington's position on new SNAs. I think that because of it arrived so late, you have to emphasise you have a complete right to reply fully as you wish on what they said, but can you give us the benefit of whatever thinking you have had in the however many hours since 4 o'clock yesterday that you've been able to devote to it?
So in respect of the comments on residential SNAs, I'm not entirely clear as to what the submitter is actually seeking by way of relief in the district plan. I'm not sure whether they want residential SNAs to be identified on the planning maps, but perhaps not subject to any rules or subject to different rules that do not purport to implement the NPSIB, but perhaps the regional policy statement 23 and 24 policies instead. I'm not entirely sure if that's what they're seeking either. In respect of the SNA extensions, I think this can be wrapped into potentially some those site visits which Mr. Goldwater and Miss Fowle from Wildlands will conduct in respect to Mr. Layton and Mr. Edmonds' properties. So that there is potentially a package there. I do have the maps which they provided of where those areas are, but no information from them whether this be private land or public land. Some of it definitely looks like it's private land over in the Makara area. In any case, these areas would be extensions to SNAs which have already been notified in the plan. And by the time council comes to making its decisions on these, the possible inclusion of these areas next year, assuming the bill comes into force, they would not be able to be identified as SNAs per Mr. Whittington's legal submissions and the advice in my 42. So I think at best, we might be able to go and visit these areas and validate whether they do meet the criteria. But the question of whether they can be identified in the district plan and whether there are any natural justice issues because they're privately owned, I do not have an answer to those points at this time.
That's helpful. Thank you. I think in terms of based on the bill, where the bill is currently sitting, or it may not stay sitting there, they could be identified, but they couldn't be implemented for 3 years. And within that 3 years, the expectation is that the goalposts will shift 180 degrees, and who knows what the regime would be at the end of that 3 years. So we'll have a discussion with the friendly folks at the Regional Council when they arrive. Returning to P4 and restoration incentives, that you've at paragraph 548. Okay, but the Commissioner has one earlier than that.
To interrupt, but I do have one question in relation to going back to your paragraph 517. And this is in relation to the original Eco P2, now becomes P7. And you responded there to Ngāti Toa's submission at 517, supporting the removal of that initial wording, opportunities to enable, and that's all clear. However, you've not addressed their other request, which was to delete the wording at the end of the policy to exclude commercial use. And so I'd be interested in your rationale of that. And particularly in light of the express provision that's been made for the continued operation of quarries in the same policy, which obviously has, it's a commercial activity. Yeah, and the overriding imperative, I guess, being to ensure that the nature and scale of vegetation removal is sufficiently curtailed to maintain biodiversity values. So, and in that light, in that regard, I was thinking that there may also, and I'd be interested in your view on this, be a potential inconsistency perhaps with the NPSIB objective 1B4. So that's around maintaining Indigenous biodiversity while providing for social, economic and cultural well-being of people and communities. So, sorry, that's a real mouthful, but it all relates to the exclusion of those commercial uses and giving clarification, the rationale there.
Thank you for pointing that out, Commissioner. I think it is an oversight that I hadn't addressed that excluding commercial use deletion as sought by Ngāti Toa Rangatira. Upon revisiting that, I think it would be appropriate to remove it for the reason that clause 310(6)(b) in respect of the avoidance framework, at least, makes it clear that the sustainable customary use of Indigenous biodiversity is not managed under that regime. I've taken that a step further in respect of dockland, where I've recommended that dockland be excluded from the chapter altogether. I can see that that would be a sensible thing to do, given that there's so much regulation already in respect of managing dockland, and this would be another layer. Unfortunately, the council itself does not benefit from such an exclusion from the MPS, much to some disgruntlement. Considering that, the MPSIB doesn't address this matter of whether that customary harvesting be used eventually for a commercial purpose or not. It's rather silent on it. I could see a case that this policy and the respective rule should also be silent on it.
I mean, could it be argued the other way?
Definitely, yeah, it could be. I guess coming back to my intent, I outlined yesterday on my methodology to giving relief to mana whenua in light of deferring other parts of the plan. I have tended to be very cautious in rejecting clear submission points from mana whenua around what outcomes they want, or and being very careful about when other submitters are purporting to provide relief to mana whenua when they may not be actually doing so if mana whenua are asked. I think this is one where on balance it would be sensible to adopt the relief of Ngāti Toa Rangatira. I've got no reason not to, but I think it would be
on the basis of transparency. I think you should. We'll take that as your initial indication and ask you to firm up with reasons in your reply.
Yep.
Or firm up, or you turn as you decide is appropriate. But
yeah, I'd also be very keen to hear the verbal submission as well, and to learn a bit more. I think they're at Ngāti Toa are attending. Actually, I must check.
Don't think so.
Okay, perhaps they're not.
You may be lucky.
But certainly I can address that in my reply.
Thank you. 'Cause
Um,
there are, of course, situations where there may be potentially, I'm not suggesting would be in this situation, but there are potential commercial uses, if you like, for the native plant material that might be harvested for Rongoa Māori, for instance, medicinal purposes, that may be given on a koha basis, or it may be sold at the market or in a shop. But you know, there's a whole customary commercial kind of argument around that too. That probably would be consistent, or could be argued to be consistent with the cultural, social, and economic well-being aspects of the NPS as well. So, I mean, I did want to draw that to your attention, which I'm sure you're aware of. I wondered whether that might have been at the heart of the exclusion initially, but it is, you know, it is something that does need to be mind. And the other aspect, just while we're on that policy, that I did want to clarify with you was around the limitation of the limitation to exercise and customary harvesting practices by tangata whenua in terms of this policy. And I just wanted to check with you as to the rationale for that. And I realise there's no scope, there are no submissions, I don't think, other than what discussed, to expand the focus. But I'd be interested in understanding, you know, why the focus on customary harvest. It seems to me that is one aspect of a cultural activity that might be conducted in relation to an SNA requires the removal of, you know, some vegetation, but there are others too that might be in the context of exercising kaitiakitanga, for instance, and undertaking cultural monitoring, that might also require the removal of material, Indigenous biodiversity material, or culling, or you know, something of that nature. So I'd be keen to hear the rationale for that.
What, more simply, is the word harvesting required?
Yeah. Yes. Yes, exactly.
Yeah.
Just be
Customary practice?
customary practices.
So I think to some extent we're kind of stuck with the definition that was notified in the plan. So there was a definition of customary harvesting hohake. And I'll have to, it hasn't come up in this hearing. I'll have to check whether it was addressed in any other hearing. But as defined in the plan, it was means harvesting of Indigenous vegetation by mana whenua in accordance with tikanga for traditional uses. And it's an inclusive, not exclusive list. These include kohikai, food gathering, whakairo weaving, whakairo carving, raranga weaving, and rongoa, traditional medicine. So there probably is some pretty good scope for a number of other activities within that non-exclusive list.
So what you're really saying is the definition means that harvesting has a broader meaning than you might otherwise think.
Correct. In respect of the activity itself, so turning to raw eco R1, which is where it's implemented, it's not encumbered by any standards, so it is quite generous
Yes.
in eco R1 A4, and from memory there were no submissions sort of seeking any change to that either, so I think it's one of those things that's a construct of submission scope, what was notified. And then, of course, the ability to revisit things more fulsomely in the Te Ao Māori plan change would be another thing I'd recommend.
Yes, I'm comfortable with that. Thank you.
Okay.
Sorry to interrupt.
No, not at all. That was useful. Thank you. It's talking about P4 incentives. You make the valid point at 548 You can't commit the council to monetary expenditure that's not in the annual plan. But the question might be, I don't think the submission was seeking an absolute commitment. It was saying where possible. And so the question might be, is there scope for a more qualified commitment? Or well, not even a commitment of any, a more qualified reference to that something may be possible, and you've sidled up to a non-statutory method, which arguably does that, but. But
Yesterday, Commissioner Dash and myself had a good discussion about including another non-statutory method to do with incentives and providing some direction that the council would consider to do so. And I think that's a reasonable addition to make. So I can provide some wording in respect of that. And I think that's fair, and it helps strengthen the case for those landowners who have asked a number of times for some assistance. So it wouldn't sign the council up, but it would provide some good direction that it's codified in the district plan that this is something the council should consider, and would provide direction to do so.
Okay, so just grounding that out, I think my reading where you landed is there's merit in it. Just requires some more thought about how it's expressed. Is that fair?
Correct. Yep.
Can I just get some further clarification around that one, because it seems to me that there is a distinction between the financial incentives potentially provided for landowners and community groups, as opposed to Tālaki Whenua, where there is a more specific requirement in clause 3.213, where councils must consider providing incentives for the restoration in priority areas on specified Māori land. And I mean, and I know we did sort of touch on this yesterday, and my understanding is that that will be dealt with more fulsomely at our Māori plan change. But in this context, I think it would be helpful for us to have an understanding of the extent to which, if any, thought has been given by the council to considering how that requirement might be met. And in that regard, you know, is a non-statutory method the most appropriate way to identify priority areas for restoration? You know, in light of the fact that clause 3.2.1 specifically requires that the district plan includes objectives, policies and methods to promote Indigenous biodiversity, and the incentivisation aspects of that closely, well, they're part of it, part of meeting that requirement. So I'd be interested in your views on that.
Yeah, part of the reason why I went with a non-statutory method, Eco M1, in terms of prioritising areas for restoration, is that it threw out many questions for me about who is prioritising. Is it council doing the work? Is it landowners are supposed to prioritise on their own land? What support are these people having? Does this give right of access? Like, it threw out many questions for me, which I didn't think it was appropriate for the district plan to answer at this point in time, or provide any direction on, and to retain a bit of flexibility for some more detailed work on those restoration, on what a restoration package or strategy might look like. It was better to give some wiggle room through a non-statutory method. This one that I've drafted so far doesn't address that incentives component, so we definitely need a separate one, I think, in respect of incentives. But I think that the package which I have recommended does, at an objective, policy and method level, I think it is at a high level consistent with that 3.21 thrust, but it does not differentiate, as we've discussed, about specified Māori land or how Māori might need to be supported differently to other landowners. And again, I hate to kick everything to the Te Ao Māori plan change, but that should be the vehicle in which that should be addressed.
I suppose the thing that occurs to me is that the development of the questions you were asking yourself, Mr. McCutcheon, that if you think about the function of a district plan being to ultimately control land uses, how would it ever be appropriate for an incentive type program to be a statutory provision? Because it's never going to, like, it might be maybe a matter to take into account in the exercise of a discretion, but that would presumably be it. That
Yeah, I am in agreement. I don't think
and it would only be like at that level when you've got a long way down the track, having already identified your priority areas, because it's only at that point that you have something that could be had regard to.
The focus for my recommendations in this chapter in respect of restoration has been to not get in the way of it occurring within the somewhat, in my view, short-sighted bounds what the NPSIB is actually making us do in respect of restoration. I think that's the most meaningful difference it can make, is not putting barriers in front of people doing this. And I'm sure we'll hear, over the next few days, views that the district plan, will get in the way of people, taking care of their land and being encouraged to do so if it might, get identified as an SNA in the future. And that's, to the point of the Capital Kiwi submissions. But within the bounds of this NPSIB, that's making us identify and protect things through a pretty strict regulatory framework. That has been my focus, is trying to not get in the way. So permitting restoration, ensuring that people can take exotics out within an SNA if they're replanting it with indigenous vegetation. Those things weren't codified in the notified chapter, and I thought that was a problem.
I move on to the discussion in relation to P7 at 582 and following. And this is where the focus is on identified values or all biodiversity values. The understand the point you're making about that these have been identified on a desktop basis, but I wonder if that sort of sells short the extent of work Wildlands have done analysing and recording the values they have, because it's a big step to shift back from the values that are identified on the face of the plan and saying basically there has to be an ecological assessment whenever anybody does anything, because you don't really know what the values are that you're affecting. That has very significant cost implications across the range of activities. Basically, you're saying you can't rely on what's in the plan. It's sort of it's almost that it's certain enough that we should define them, but not certain enough that we can rely on them. There is something of a non sequitur there.
It's tricky, and I think this recommendation is finely balanced. And in turning my mind to it, I considered how is this different to a heritage building, for example. I think the difference there is that for a particular heritage building, there has been, or there is always quite a detailed assessment that's undertaken of that particular place with, usually some pretty precise information about its values, how it's changed over time, what it represents, down to that site-specific scale, which, as we've discussed, has not been the case with the SNAs identified in the plan for reasons of efficiency in getting the assessment done in a desktop sense. And I think, there definitely will be areas where there will be vegetation that doesn't meet the criteria, for which, unfortunately, an SNA may have been identified on a small portion of a site. I think that was a line of questioning with Mr. Goldwater this morning. I think, notwithstanding that, it is possible that values will change over time. We spoke about how SNAs have regenerated. It's foreseeable that new or different types of vegetation could self-seed. Perhaps that area could then meet the criteria for diversity and pattern where it had not before. We've spoken about how there wasn't to my knowledge as well, a considered approach taken to identifying tangata whenua values in SNAs, and it is possible, entirely possible, that some of these SNAs do have tangata whenua values for which they haven't been scheduled in Schedule 8. So I wouldn't want to preclude consideration of those values. And I know that doesn't give much comfort to the view that a resource consent applicant should be certain as to what values they should be assessing when they're putting together their application. But I think any kind of values-based control is going to have a level of subjectivity, unfortunately.
That's fair. Thank you for that.
Certainly don't want to undermine the work that Wildlands have done to identify all these values, just to be clear.
Question might therefore be, Forest and Bird sought in their submission provision for SNAs to be identified in consent processes. And I didn't see any specific discussion of that submission, although obviously in a document this big I may well have missed it. But the same logic might suggest that there's merit in that submission too. So let's, stepping back and say, let's talk about the Forest and Bird submission, that the SNA provisions should not just apply to the identified SNAs. They should apply to anything that's identified as an SNA in future.
I guess mechanically that doesn't work, would be my response to Forest and Bird. It either is identified as an SNA or it is outside an SNA. And in part relief of what they're seeking, that's where this proposed outside SNA control would manage biodiversity values, ensuring that the effects management hierarchy was applied if adverse effects were to be significant, or otherwise be minimised or reduced, or wherever I get to in my right of reply for that second limit of that test. But mechanically, it either is an SNA or it's not. You can't apply rules to something that, on the basis that it might in the future be identified as an SNA. That would be my perspective. I guess maybe also in part relief of what they're seeking, there could be matters of discretion or assessment criteria that allow for that potential biodiversity values to be recognised. I spoke yesterday about some of the matters of discretion or the assessment criteria in the earthworks rules in respect of the replanting Indigenous biodiversity as a way of stabilising a slope. There would be some benefit there, but it's either an SNA or it's not. And if we work forward with our with this outside SNA control, that would manage those effects, or it wouldn't, on the basis that we are satisfied objective 1 of the NPSIB would be met.
Well, I'm not sure that that's consistent with case law, because I was thinking the Basin Bridge Board of Inquiry decision turned on a heritage area that wasn't identified as a heritage area in the plan. And I seem to recall the Project Hayes Environment Court decision in about 2009-ish, turned on an O&L that wasn't identified as an O&L in the relevant district plans.
So to clarify, an AEE would have to identify all the range of effects that would arise as part of an activity, but the application of the SNA, the eco rules per se, mechanically would not be engaged if it's not identified as an SNA.
What about policies?
It would depend on the activity status if it were.
Yeah, but
Just-
assuming it were a full discretionary activity, if something on examination was found to meet the SNA standards, but hadn't been identified as an SNA, should it be treated as an SNA at least for the policy at a policy level? Mr. McCutcheon's looking at you, Mr. Whittington.
I was going to say, based on the way the NPSIB is structured, I would have thought no, because it doesn't, the whole, the implementation process it envisages requires identification, following which you go down one path, and then there are the outside SNA second path. So it seems to me consistent with that it wouldn't be engaged in that kind of scenario, or at least the NPSIB doesn't require it. That's not to say you couldn't come up with a framework that's consistent with the NPSIB.
Yeah.
But
Okay. So the fundamental answer to Forest and Bird is that maybe at a policy level, but in practice, you can't write rules around something that's not currently identified because it lacks certainty, effectively. In terms of your suggested discussion about Rule 1 about focusing on lawfully established roads, also access ways, driveways, rights of way, where vegetation is limited. It occurred to me that there's an interface with the stock exclusion regs, which are requiring farmers to fence riparian margins. I think that's shifting. Not sure if those regs have been amended, but because under the previous government they referred to slope maps, and I know that the current government has got a fix on whether those slope maps should remain. It considers they clearly shouldn't, but I don't know if that's been actioned yet. I can't remember. But Okay.
The winter grazing.
Because that's been
Yeah,
and
was part of.
that was part of that. But the stock exchange, the essential element of fencing riparian
Mm.
margins that may well overlap with SNAs.
Mm.
And of course, fencing requires a clear space
Mm.
in order to put fences in. So is that and you're saying you could only have lawfully established tracks, and is that something that needs to be provided for?
Certainly, I think that with a change I've made in Eco R1 to A1 would preclude new fencing within an SNA. I had not considered the stock exclusion interface there, so that would be something I'll return with some more advice on. But it does appear that I would have to take some advice as to how the regs are intended to interact with the MPSIB and whether they're supposed to prevail.
That's
Or not.
It's
I don't know.
optimistic that anyone thought about that. But as I say, like, can I just draw that to your attention?
Yes,
Just
thank you.
as something to think about. That as we are advised by weary farmers, assailed by regulation from all corners, about whether the regulators are talking to each other. Yeah, go.
Just a follow-on question that springs to mind in relation to and enabling Tainui Whenua to exercise customary harvesting. I'm not anticipating that the definition would include such things as maintenance of tracks for customary purposes. I'm thinking in particular about urupa tracks. Where, for instance, in our situation, we have an urupa on a promontory, so you have to climb the hill to get to the top. And while the urupa itself is Māori land, the track that's required to get there is not. It's general land, and that track needs maintaining, constantly to provide access to the urupa. And it's just something that springs to mind because I'm not sure that, for instance, would be covered by any of those provisions or clauses in Rule 1. I could just give you a minute to think about that, and perhaps it would be something that would be dealt with in the process, but it's quite an important issue.
I think I don't think it would be captured or covered within the definition of customary harvesting.
Yes, I didn't think so.
I think the opportunity would be within Eco R1 1AI. So the first clause, which I've noted is worded slightly differently to the more high level Eco P72, which talks about tracks and access ways.
Yes.
So I think if I will turn my mind to whether that difference is intentional or could be narrowed down.
Yes.
I think that would be the vehicle unintended for some relief to ensure that those activities could continue with the scope of submissions that I have.
It might come back to the question we were discussing earlier, whether one is talking about just legal interests in land,
Yeah.
or or might extend, or extends to, like, because I think what the commission is talking about is a private access way
Yeah.
that
Use.
may or may not be an easement,
Yeah.
but it probably isn't,
Use.
but is recognised, is established, arguably lawfully established. It's not unlawful.
No.
But so that might
Mm.
merit some
Yeah.
thought.
I think you're right. I think it's a bit of both. Some of it will be legally established, others will just exist, and they were lawfully established at the time. So
Mm.
Okay. What's that, sorry? Where are we at? Rule 1. Rule 1, paragraph, it just started in the 600s. Yeah, go for it.
Rule R1A1, this whole issue about lawfully established as well. You've got the removal of vegetation is limited to within the formed width of the road, rail corridor, or access. That can in itself be problematical in terms of things like the other services which go into the road as well. So you're not talking just about the width of the road or the footpath, but you're also talking about the edges as well as being. So what's the intention? It probably isn't any submissions on it, but I would have thought that the more fundamental way that the plans have dealt with legal road in the past, that it is, if it is formed, it's up to the edge of the boundary. So,
like in the case of a road, includes the road reserve.
yes,
Like-
and thinking about the Reggie example as being one of them, but there's plenty of them where the actual form width of the road itself is only like 10 meters, but the legal road is 20 meters.
Yeah.
So what's the intention? Is it just the form road rather than the other stuff which has been held for a reason, often been held for a reason?
So to start, SNAs have been identified in road reserve. The amendment which council committee made only removed SNAs from privately owned residentially zoned sites in effect. So the legal road that was zoned residential has retained SNAs on it. There's a relationship here with the INF eco chapter as well in respect of clearing vegetation. So to ensure under INF Eco R41, the operation, maintenance and repair of existing infrastructure within an SNA, standard INF Eco S19 provides 2 meters of clearance.
Yeah.
I think one answer to the commissioner's question is that the reference to road and rail is going to come out of here because it's infrastructure.
Correct.
It go into and it be addressed in the infrastructure eco subchapter, but what the intention there is that it's addressed by that.
Correct. And again, it's one of those things, you're right, there's not a hell of a lot of submission scope on the INF Eco standards. Yeah, must be limited within 2 meters of the footprint of the existing infrastructure. So I would take that to mean you can push back within 2 meters from
Edge of the form carriageway.
Well, the
That's all right.
infrastructure might include a power pole that's sitting in the road reserve, or a telecommunication, like a fibre optic cable that's running parallel to the road in the road reserve. So it's just 2 meters back from that rather than 2 meters from the road.
Or it's a lateral service connection to the property next door.
Yeah.
That too.
I think it would play out differently depending on where the infrastructure happened to be located.
Yeah, but it's pretty broad ranging.
It is.
I know we're talking about it within R1, and we should be talking about it within the the INF
Mm.
part of eco, but does appear that could be problematical to a number of routine utilities which require access to legal road.
Okay, we'll come back to it when we get to the eco subchapter then. Kachin, something for you to note for your accept reject tables. 632C. I think that should be accepted in part because you've got an exclusion for pest vegetation.
Okay. Mm.
Going to page 187. 664. Any advance on 664, people? 663 says you don't have any scope to change the rule. And 664 says there's a gap and you need some information requirements. So where's the scope for the information requirements coming from?
So in respect of Eco R4, the change which I would have liked to have made, I could have been a bit more clear about that, would be to make that a discretionary activity consistent with the other rules in the chapter. So I definitely didn't have scope to do that. I'm a bit of a fan of using consequential amendments where there are benefits to
Yes,
resource consent applicants.
Consequence of what?
The same wording being applied in other rules.
Where there is scope.
I can find some scope.
Okay, can we just record that as part of your reply, can you please identify where the scope for the recommended change is coming from?
Certainly.
Related to that, and I don't know where I read it, of course, but in the past you've said that in terms of MPSIB, you did consider that discretionary was a more appropriate activity status. I don't know where I've read that, but I've got it noted.
You didn't make it up. Yes, it's definitely there somewhere.
Yeah.
So it's paragraph 631.
I also just wonder, reading 664, if it's not a clause 16 amendment.
Well, that's what I put in my margin, clause 16 question mark.
Mm.
And that may be the answer that
Yeah.
McCutcheon gives us in reply.
The same could apply to the previous rule R3, where you've at 655, you've acknowledged there were no specific submissions, but it's yours consistent with those general submissions.
That's it. I think that rather than cast around and decide scope issues across the table, we just invite Mr. McCutcheon to give us chapter and verse and reply. The terms of standard 1, the test works are essential due to imminent threat to safety of people or property, and council's advised the threat. I wondered about trimming to comply, that people undertake to comply with the electricity tree rules, the separation of lines, which is where there's not a threat when it's like, I think it's 1 meter, and obviously it's still not a threat when it's 90 centimeters, but it's in breach of the rules.
So I think, again, this is one where the INF Eco chapter is engaged. And I wonder whether the introduction to the Eco chapter should also make a comment about those electricity hazards from trees regs as well, in addition to renewables and INF NG, because the standard S19 and the INF Eco S19 says that it does not apply to works in accordance with the electricity hazards from trees regs or the Telecommunications Act.
So is that like the thing that was going through my mind as you were talking about that is that that's not a, it's a work to protect infrastructure, but it's not by the infrastructure provider. Well, obviously some infrastructure providers do. I think Transpower does. They don't wait for the landowner to do it. They go and do it themselves. But for most landowners, it's on them. Not to trim vegetation that's coming too close to their inward power line. Is that an infrastructure activity? It's sort of related to infrastructure.
I believe it is.
Is it, well, or is it defined?
Yes. So
do you think? So so that
so
and if it is, if that's the answer, would there be merit in an advice note pointing people to that?
Yeah, I definitely think there's some benefit in having that reference in the Eco chapter somewhere saying these rules do not apply to those hazard tree regs for electricity purposes, and pointing people towards the infrastructure equivalent, because I think it's foreseeable that people won't think to look in that chapter. That's entirely reasonable. And you know, the infrastructure chapters are geared up for the operators, but in this case it's individuals who also have a responsibility to manage trees on their properties. Yeah, agree.
I think we'll await your recommendation as to what it should say and where it should say it.
Yeah.
The S2, the You may have addressed this in rebuttal, and this may be, have some recollection of that. The standard being talking about 2.5 in width is was obviously derived from the fact that where this rule started was with tracks, where you're obviously talking about a linear operation and therefore width is appropriate, but it's now expanded to quarries and maintenance and repair of existing buildings and structures, where it would seem that an area would be more appropriate. Width doesn't quite work. Like it's hard to understand why a squat area of bush is less is more of an issue than a long thin strip. If they're the same length, same area, and a track might be quite a large area if it's long enough. So what's your reaction, and have you dealt with it?
Yeah, so how I thought about this was, so in my rebuttal, in response to Ms. Whitney's suggestion that an area-based trigger be applied, how I saw the standard working, let's take an example of a walking track. If that track was 1.5 meters wide and you had 2.5 meters in total width that you were allowed to clear, you could clear 1.1 meters on the left-hand side of the track and 1.4 on the other side of the track. So in total, 2.5 meters was cleared. So that would be the total width of 2.5 meters clearance. Likewise, if you could choose to have all that 2.5 on one side of the track and have bush right up against that side. So that was the example that I put in my rebuttal for the quarry zone, where I recommended that width be increased to 5 meters. In terms of maintenance and repair of existing buildings and structures, I think it probably would benefit from width maybe being, in that context, depth. That might be a way of doing it. Again, I think the intention would be to allow people to push back vegetation from buildings to allow maintenance to occur. Now, and my understanding is it has to be quite narrow or tightly defined, because we're trying to implement that clause 3.15 specified activities, and that the effect of the clearance can't be any greater or must be minimal, essentially under 3.15.
Yeah, and I think the issue is, to me, is width. Doesn't seem to be the right test for the extended range of activities.
Okay.
Width is certainly appropriate for tracks.
Yeah, but for buildings, yeah, I can turn my mind to what that would look like.
Buildings might be.
Yeah.
There's something for you to consider.
So just in relation to that, so you removed quarries from S2.
Yeah.
And you put it into S3, which is where the 5 meters comes in.
Correct.
Yeah.
So I'm looking at the.
Yeah, that's
Mm.
okay. But the issue remains anyway in terms of buildings and structures
Agree.
under S2.
Yeah.
Yeah. That's just what.
Okay,
Yeah.
gotcha. Yeah, so, but it's the same issue in S3.
Yeah.
Sort of.
Yeah.
Well, and indeed, yes, for them, no. Going to principles for biodiversity offsetting on page 201. Number 3. I appreciate that this is probably straight out of the NPS, the appendix. But I wondered if there are some words missing at the end of the chapeau of sub point 3. Something like in terms of, because it doesn't see no reason why we shouldn't improve the English while we're on the way by.
I agree.
Just on the that appendix 2. So the Greater Wellington submission, the RPS change 1 recommends a 10% net gain. So are you saying that it's not required, it's just preferable? That's why you.
Yeah, so being picky with their words, the RPS PC1, it prefers, it says it's preferable that there be a 10% net gain, not that one's required.
Yes.
And considering the directiveness of the MPSIB and that it's not in conflict with the preference of the RPS, noting that's not required,
Yeah.
I thought it was appropriate to just entirely copy the MPSIB.
Yeah.
Text.
Thank you.
Paragraph 724. The saying clause 10 refers to financial contributions. You don't propose to include any rule, which should be in a future plan. Consequently, this clause of the compensation framework would be unenforceable. Would there be a problem more than it be unenforceable? It says it wouldn't allow for it. It wouldn't allow an applicant to offer compensation.
Yeah, I think what would remedy that would be, if the words in my 42 had said would not allow the council to take or require a financial contribution, but yeah, I agree, an applicant could still proffer one.
So it needs.
This clause of the compensation framework would not allow the council to require a financial contribution.
But it would, it sort of would allow it if offered.
Yeah.
The going to appendix 15. at page 210. Identifying any effects on identified taonga. Who's doing the identifying in relation to taonga? Identified taonga, identified by whom?
Mm.
This identified by the ecological assessment or by mana whenua?
Yeah. So I think there's a bit of a timing issue here in that I'm recommending aligning the appendix with the information requirements with the MPSIB, which this appendix has been written assuming that councils have done the work to work with mana whenua to identify those taonga species, whereas that has not happened to this point in time. As such, if you were to agree that this wording should be pursued and the chapter confirmed as such, there would be a period of time in between then and those species eventually being identified in the plan through the Te Ao Māori plan change, where there wouldn't be any identified taonga in the district plan per se. So there is a little bit of a timing issue there. In the first instance, those taonga species would have been identified by mana whenua, and then an applicant would be required to take note of those identified species and identify any effects of them in there.
So if you were to expand it to cover it fully, what you mean is, well, what is meant by is identify any effects on taonga that are identified by mana whenua and recorded in the plan.
Correct.
And therefore I wonder if it should say that.
I agree, that'd be sensible.
Just while we're on appendix 15, and I hadn't noticed this before, but 2D says identify the ecosystem services associated with the indigenous biodiversity of the site. Not really too sure what ecosystem services means.
Things like CO2 production,
Not a term I've heard before.
So
should have asked Mr. Goldberg.
Is it,
I think you would have got
has
chapter.
a genesis somewhere, presumably.
that's a good spotting there, Commissioner. So in section 10.2 of my report, I recommended a whole lot of new definitions for which I'm going to find submission scope, or say that they're otherwise consequential or minor, to interpret the policies of the plan, and that's one that I have missed. So there is a definition of that term in the MPSIB,
Yeah.
and it should be included. That would be my position, and I'll return to you my right of reply on that one.
So the interesting thing is,
What does it
say?
It says supporting services such as nutrient cycling, soil formation, habitat creation, provisioning services such as food, water, fuel, fibre, regulating services such as purification, climate regulation, flooding, and cultural services, aesthetic, spiritual, education, and recreational.
Okay, thank you.
The moral of the story, learn something new every day. They are going now on the INF Eco subchapter. Paragraph, I've just read and got the answer point further down. Your paragraph 12.7 or section 12.7, page 233. That's something you went earlier?
Yeah.
Go for it.
Your paragraph 763, where you talk about navigation installations in Wellington City, provided through PDP designations, given this appears to be Airways' preferred method. Navigation installations aren't only for planes though, they're for ships as well. There's quite a few around the Wellington coast.
Can you repeat that so I can write that down, please, Lindsay?
So it's para 763.
Yeah.
And it's with respect to navigation installations in Wellington City, primarily provided in the PDP through designations. And then, given this is Airways' preferred method for navigation installations, I don't consider it sufficient to provide a different framework solely for such infrastructure.
Mhm.
I just got a little bit confused about navigation installations and whether they are really for airplanes or they're for ships too. You often see the big triangular
Mm.
ones.
Agree. So I've turned my mind to the definition of infrastructure in the RMA, and clause J identifies a navigation installation as defined in section 2 of the Civil Aviation Act. It does not appear to be.
It's not in the Maritime New Zealand regulations. I don't know. It just didn't suit.
Yeah.
To me, navigation, I automatically think of ships first rather than airplanes.
I guess where the maybe the rub comes from is the definition of specified infrastructure, and that refers directly to regionally significant infrastructure, RPS PC1. I can turn my mind to seeing if there's anything that I've missed in respect of those structures. And lifeline utilities is defined in the CDMA, and that at face value, appears to be a gap for both those kinds of navigation installations.
Another question might be, are there any navigation aids for boats that are not within the CMA?
I don't know for sure, but presumably the lighthouses are above the CMA.
Well, yeah, well, are there any lighthouses within Wellington City? There's obviously one at Pencarrow, but that's in.
I thought there was a lighthouse, and I could be wrong, out at Terrafiti.
Out on
the south. I could be wrong. But it seems to me that there's a big promontory as you go there that they would have, and Pencarrow is around the corner, that they would have had something there. I could be wrong.
Like, I suppose, assuming there is at least a possibility of navigation aids for maritime use, should the plan provide for it? You would expect that it would be somewhere out on the south coast, in which case it's probably all, which is got heavily regulated in terms of, you know, ONL, ONL's coastal natural character, all of those things. So SNAs might be the least of the issues, but at least in principle, I think we'd invite you to consider that, please.
Mm.
Liz, did you have something?
It's okay. It's thinking like a big jump.
Um, So going to 233. So you're relying on policy 6, the CPS. And I'm wondering if we're pushing that too hard, given where the majority in East-West landed, which is that the leeway for infrastructure in the coastal environment to do other than avoid effects is shrinkingly small. There is a leeway, but it's not very big.
Sorry, are we talking about policy 33?
Well,
Or which paragraph?
I think it's page 233.
Oh, page 233, sorry, yeah.
So it's paragraph 814. The subject matter is 41.
So I guess the crux of it was that Forest and Bird was seeking a more restrictive activity status for the operation, maintenance, repair or removal of existing infrastructure within a significant natural area. And I didn't consider it appropriate that operation, maintenance and repair should cascade to a non-complying activity status where those standards for trimming and removal, those minor standard, the 2 metre one that we talked about earlier today, and the earthwork standards weren't met. I considered that a restricted discretionary activity status was suitable. And there's a relationship to my rebuttal where I addressed Miss O'Sullivan and her relief sought, where in that case, the airport was wanting recognition and greater alignment with the MPSIB cascade for regionally significant infrastructure that couldn't meet the existing or the established activity requirements of clause 3.15, and then it is accordingly assessed against the effects management hierarchy approach, but it also needs to demonstrate an operational need or a functional need. So yeah, in my rebuttal, I provided a bit more chunky of a policy in acceptance of Ms. O'Sullivan's view on that matter. And in respect of coastal matters, so in that case, the INF CE chapter would also be engaged and considered as well. But my view was that in respect of the operation, maintenance and repair, the MPSIB provided quite a directive, well, quite a clear framework for what infrastructure providers had to do where they wanted to, where maintenance, repair and upgrade would step outside of those sort of proxy permitted standards And if that infrastructure were of a national or a regional benefit, as Ms O'Sullivan was after.
Okay, thank you.
I just note in Rule 41, with your addition, as a matter of discretion, the Eco P33 has been included, but you've just spelt matters wrong.
Thank you.
Attention to English language.
So where was that? Please?
Just on. He's added a new question related back to P33 matters.
Yep.
In relation to that rule, it's just something we were talking about before about your idea that rules should be RDA. And I note that this is the only RDA. The rest of them are discretionary or non-complying. Yeah, so it's just a general comment.
I think in the context of this is quite a narrow activity. I could see an RD activity, an RD status would be appropriate.
Yeah.
And in respect of new infrastructure, I think that is appropriate. That's discretionary and that aligns with the changes I've recommended in the eco chapter proper. But yeah, you're right.
The question I had, I'm up to page 243. Southern Thread Road. The saying issues with submission scope, you're supportive of mapping amendments. Where have you landed on scope? Is there scope for a mapping amendment or isn't there?
There is no scope.
Okay. Well, that was all the questions I had on your 42A report. Any other before we go to reply? Rebuttal? Maria.
Just a couple of further clarifications from me. And sorry to have to do this, but I'm going to have to take you back to Rule 2 just briefly. Subsequent to the chair having dealt with this earlier, it occurred to me that the restoration and maintenance of significant natural areas intended to be implemented through Rule 2 doesn't include, well, I'm presuming this ties to policy Eco P9. Is that right? And if it does, then P9 requires protection as well.
You mean the notified Rule 2 or the revised?
These are all in the revised.
Gotcha.
So I'm looking at yes, R2 in relation to the revised Eco P9, and that's the one that it applies to, isn't it?
Yes, and there is a difference in the clause. P9.1 talks about providing for mana whenua to exercise their responsibilities as kaitiaki to protect, restore and maintain, whereas the notified R2 clause 1A 5 just spoke about mana whenua in accordance with the principle of kaitiakitanga.
Yes.
But-
So that's fine, but my issue is really around protection, whether we needed to carry that through, whether
Mm.
that needs to be carried through to the rule. Because the Eco P9 does actually now include protection and restoration in relation to all aspects of that. See, so the sanctuary trust and also landowners and community groups.
Mm.
Whereas before, I think it was just to maintain and restore, wasn't it? Anyway, the mana whenua are, they're carrying out all three aspects as part of their kaitiaki responsibilities: protect, restore, and maintain. And the others, oh yes, no, they are also protect, restore, and maintain for community groups and landowners. And then the Karori Sanctuary is just protect and restore. I presume that's intentional.
Yeah, I think this is a situation where we're sort of stuck with the notified wording. And I don't actually think that the words protect, restore and maintain are needed in those clauses, considering that the SHAPO itself addresses
The SHAPO.
those matters.
Yep.
Yeah.
So, although the SHAPO for P9 doesn't include maintain, but I suppose it's inherent.
I think you could take protection as a synonym for maintenance.
Yeah.
They're not quite the same thing,
They're
but they're
not
close.
Yeah.
They're close. However, R2, the SHAPO doesn't include protection.
Mm.
It's just restoration and maintenance.
It's all quite odd that it's restoration and maintenance rather than the other way around.
Yeah.
Mm.
Yes. All got jumbled up there. By the looks of it.
I can revisit that matter.
Thank you. And just another matter in terms of the wording of clause A5, 1A5, there, the mana whenua. It doesn't really make sense to be saying that the works are for the purpose of restoring or maintaining a significant natural area by mana whenua in accordance with the principle of kaitiakitanga. I think it needs, like all the other clauses have there, a doing word.
Right. Yeah. Mm.
So even if it was mana whenua exercising,
Mm.
say kaitiakitanga in accordance with tikanga Māori or something like that,
Mm.
it would make better sense.
I agree.
And then in relation to Eco M1, clearly that contemplates that Wellington City Council and the Greater Regional Council will be working in partnership with mana whenua, and that would appear to be consistent with the NPS IB, which requires local authorities to involve tangata whenua as partners in the management of Indigenous biodiversity, but only to the extent that they wish to be involved. And so I'm just, again, I think I know the answer to this, but wanted to check with you as to whether there's been any specific consultation with tangata whenua in relation to this particular provision to confirm their desire and commitment to work in partnership with the councils in relation to restoration of Indigenous biodiversity.
In respect of Eco P91.
Sorry, Eco M1.
Oh, M1. No, so I have not engaged with Mana Whenua on the wording for this this method. That's one which has come directly from the wording in the MPSIB. I would hope that in that Te Ao Māori plan change, the wording is examined, but I think in any case, it is the right wording as to what the council should do.
I understand that.
Mm.
So it sets out a clear intention.
Yeah.
right?
Yes.
But does it,
It-
it's, I mean, not gonna, it's not creating any inconsistency issues. For the district plan in terms of meeting the requirements of the NPS in this respect.
I don't think so. I think if the concern was that it was signing Mana Whenua up to work that they could not do, we could soften it by having a clause that acknowledged that Mana Whenua may not want to or have the capacity to be involved.
Well, I wonder if the answer is to say, rather than will work,
Yeah,
will seek to work.
Mm.
yes, that would be better.
Because you're committing the councils, but you're not committing anyone else.
Yeah.
Because you can't.
That one. And then just one final catch-all. Just wanted to double check that the provisions, policies that stand out to me in relation to tangata whenua issues are around P7, P9, P10. These are the renewed numbering.
Mm.
There may be some ones that I've missed there, but that recognise specific activities that are appropriate within SNAs that contribute to wellbeing. In P7, I think allows appropriate vegetation removal in SNAs, including or hauhake or cultural harvest by Mana Whenua. And P9 provides for Mana Whenua to exercise their kaitiakitanga to protect and restore and maintain Indigenous biodiversity. And my question really is just to clarify that these policies and any other, related provisions in the plan are not intended to be confined in their application to just those areas or SNAs with identified tangata whenua values?
No, and I think to go back to my methodology I set out yesterday, there's a lot more stuff that needs to be done in this to implement this MPSIB in full. And this is only a halfway house, which I've recommended at this point in time. So there's definitely a lot more that needs to be done for those provisions that I've recommended to be deferred. And even in the context of the provisions that I have recommended, they need to be put through the lens of through that in that Te Ao Māori plan change consultation and in partnership work. Is this doing what Mana Whenua want this to do? Because I cannot hand on heart say even this is right now, considering the submission scope which I've had to work with, and the fact that I haven't engaged with Mana Whenua to date.
Thank you for that clarification. Just wanted to make absolutely sure that there isn't any intention through the plan. It doesn't say that, but given that there are SNAs that will have and do already have specific values associated with them, just wanted to make sure that there's no intention to confine the tangata whenua related policies to just those SNAs. Thank you.
Looking at the clock, it's 12:30. I think we'll break for lunch and come back and discuss your rebuttal evidence.
Cool.
But I'm thinking that will be done before 2:30. That would be the aiming point. Sun's still shining for us to go and have a trip to the beach. Thank you. Adjourn until 1:30.
Like this evening, that's. For that long.
It's not like us out of Bangkok. So we so actually there's more from
resume the hearing. Mr. McCutcheon, we could discuss your rebuttal evidence. So, talking first about your response to Ms. Whitney for our Kiwi Quarry. At your paragraph 19, you refer to the MPSIB failing to adequately consider the impacts on the urban environment. Greater Wellington in its statement refers us to the RIS, which asserts that the costs are all short-term and local or to individuals, and the benefits are long-term and exceed the costs. Is there any, to your knowledge, is there any economic analysis that underpins that assertion?
I understand that the section 32 for the MPSIB did have some supporting economic analysis undertaken. Mr. Norman and I were discussing it, and he voiced his concerns about how that work was undertaken. I guess what I would add is that Mr. Norman has provided some very detailed analysis as to the economic impacts and in turn the impacts on development capacity of the MPSIB and the resulting proposals for SNAs and the outside SNA control, which I would say are more relevant to a Wellington context than the more general work that may have been undertaken for the RIS or the section 32 for the national direction itself. Notwithstanding, of course, any clarification that can be returned to you around the assumptions and the inputs into that work.
Yeah, it occurred to me that that the costs Mr. Norman was talking about in terms of loss of development capacity could hardly be described as local individual costs. They're on the community at large, aren't they?
Yes, so the costs of the proposal for the outside SNA control, and for SNAs themselves, are borne by landowners, and those benefits received to the community at large. And his evidence shows that, by and large, from a pure economic perspective, the costs outweigh the benefits by a number of factors.
And when you refer to paragraph at the end of paragraph 22, the general direction will likely come to a head, most likely when a decision to defer implementing the provisions is appealed. You mean in this process or in the change one process, or both?
Definitely in this process.
Yes. Yeah, I think that's a safe assumption. Um, Your discussion of Ms. Whitney's concern about minimising. We had a brief discussion about this yesterday. Where have you landed? What are you recommending we do with that policy that currently says minimise?
Yeah. As I've noted in my rebuttal, para 30, my view was that it would be excessive or unnecessary that even mitigation be required for effects on Indigenous biodiversity that were just otherwise adverse effects that were not significant. The significant effects are being addressed by the effects management hierarchy. So in my view, if a level of vegetation were to be removed as part of a development, and it was necessary to enable housing the development of a unit, I can see situations in which it would not be possible to mitigate on site by way of additional planting. And that has led me to thinking about whether the word minimise would be better to substitute with reduce or lessen. I can see that mitigation outcomes will definitely be achieved in respect of significant adverse effects, and they may well be triggered on a number of sites. And mitigation responses through new planting to offset or compensation being offered could be achieved in respect of significant adverse effects. But for just other general adverse effects from removing vegetation, I thought it would be unnecessary.
Does that mean that we'll end up with something like appropriately mitigate?
Quite possibly.
Tell us where exactly you've landed in reply. It's a somewhat hedged response, I might observe, but is the reality you're still thinking about it?
Yes.
The discussing what is a tree, paragraph 45, the implications of using the hut definition is that in residential areas, all Indigenous vegetation under 3 metres in height would be captured by the outside SNA clearance rules, but trees over 3 metres would not. Discussing it with Minister Goldwater this morning, he seemed to be suggesting the inverse, that what needed to be caught was vegetation over 3 metres, and he was much less concerned with anything less than 3 metres.
Mm.
So where does that leave us?
I think it leaves
Going in
us swimming in a complex regulatory environment where the RMA is carving out the ability for councils to include general vegetation rules for clearance rules, unless otherwise described in a schedule. But that might be the vegetation that has the value.
Which we can't protect because that would infringe the tree rules.
I think what's important to note is that even if residential SNAs were included in the plan, this matter doesn't go away. We're kind of stuck in this situation, irrespective of whether we do include residential SNAs in the plan, because there's clearly Indigenous biodiversity outside of SNAs, which may have some value, and then this quandary doesn't go away.
I suppose the difference is that at that point you can be confident that the most significant vegetation is protected by a different route.
Agree.
And that what's left is by definition non-significant. Okay. Need to think through that a bit further. The discussion about S2 permitted clearance, and saying you're suggesting that the threshold for clearance for quarry operation be 5 metres to align with farm tracks. That assumes, of course, that the only thing you're trying to protect, or the only right in relation to quarrying that you're trying to protect, is the right to put access tracks through SNAs rather than to actually quarry them. If, to your mind, so as I understand the rules within SNAs, the S2, the 2.5 metres, or S3, 5 metres are really the only exceptions. And there are some others that could conceivably apply. There are some others like the one in fire breaks, but they're quite a discrete purpose. They're the only general exceptions, and they're very much picking at the margins.
Agree.
SNA, which is presumably consistent with the avoid policy of the.
Yes, and I guess where the real direction comes from is 3.15, managing adverse effects of established activities. And that clause is very tight in that it requires that the effects of that activity on an SNA, this is 3.152 A and B, are no greater in scale, intensity or character over time, and do not result in the loss of extent or degradation of ecological integrity of an SNA. And so because of that, I viewed those standards as needing to be very tight or small in the level of clearance which they would enable, and is the primary reason why I did not take up the relief that Ms Whitney put forward, which was a 3,000 metre squared threshold, because I considered that there were risks that would not be consistent with 3.15 and would allow a greater scale intensity and a loss of potential loss of extent or degradation of ecological integrity. So that I guess what's important to note is that they are, again, they're proxies, but they're proxies as a result of what was in the notified plan and what submitters have sought, and that gives us the scope to come up with them. I can see that perhaps there might be a modification which I could make in respect of maybe some of the like reference to the operating area of the quarry, or areas where the quarry which are not access tracks but which trucks drive around within the main body of the operating area. I had a look on the aerial imagery to work out whether that would be a situation which would arise based on where the SNAs were identified, and I didn't think that it was. It looked to me, at least from the aerial imagery, and this is something we can test with Miss Whitney. I'd be keen to get her view as to where are those areas where operations are going to abut up to SNA, and I had thought it was primarily in the access track space.
Yeah.
I guess the other relevant dimension there is that an extension, in my view, wouldn't be an established, activity.
Referring to the discussion of Mr. Delasia's evidence and it'd be helpful if he actually produced the certificate of compliance. Have you seen it yet? No. Assuming, looking at the diagram, I think I've got to look at his evidence. Assuming he's right, and the certificate of compliance get clear. As he refers to it being attached, but I don't think it is. That's issue. So got a situation where we have residential land, assuming we have residential land, because that's the recommendation. Around effectively the outside of the triangle, like I'm sort of describing there. Not quite, there's more curves now, but diagram in the ODP is of a triangle of mixed use zone with outer residential around it. Recommendation, I think in stream 7, is that the outer part of the former outer residential go back to MRZ and you've recommended without an SNA. So that means that what we've got left is like a strip, an isolated strip of SNA. I suppose I should have asked Mr. Goldwater this question, but in that scenario, what prospect is there that that strip of SNA would retain significant values? Like I don't have a sense of how wide that strip would be, but you could maybe tell me.
Yeah, I can tell you that. So the edge of the building to the end or to the edge of the mixed use zoned portion, it's 14 meters wide. The area using the E plan of SNA total.
So it's sort of like a rectangular strip.
Yeah, about 1,200 square meters ish.
Area.
I mean, yeah. You can look at this two ways. You can say a certificate of compliance is not relevant in respect of whether an SNA should be identified on a property, or that it's a foregone conclusion that it could be removed and you may as well align with that. Certainly that was the approach of the backyard taonga work, which is that if a certificate of compliance had been granted or a building or resource consent, then SNAs were snipped back accordingly. There would, in respect of the specific question around would that still have significant values, I can't speak for Mr. Goldwater, but I'd be surprised if retaining a 1,200 square portion on that site meant that it stood alone in its significance. I think it's entirely likely that the rest of the SNA would meet the criteria to be an SNA, even in absence of that 1,200 square area.
Entirely likely
that the rest of the SNA would still be significant, even in absence of that portion. I think the thing in the back of my mind is that if this residential zoning is accepted, an outcome that would be, I would suggest that would occur would be that the mixed use zoned part would be subdivided from the residential zoned sites, and at that point, that's the mixed use zone site would be some 2,500 square meters, which falls within the urban environment allotment 4,000 square meter range. So for that SNA, if it were to remain there to be lawful, we would need to have another schedule or those trees otherwise described in the plan. That's not what has occurred to date, and it would seem, I guess, out of place that that response be taken for one particular site.
So your position at the moment is that it should stay over the MUZ?
I think if that certificate of compliance shows that it can be removed,
then
then
no,
remove it.
so your view is that it turns on the certificate of compliance.
And I've noted I don't have any ecological support or evidence to prove that that's supportable. Yes, my overriding comment would be that, you know, we're sort of closing out a process where there will be a few of these that have dragged on, the 35 that we talked about in the last yesterday that have been granted since 2019, I think it was. Some of those will carry through, some of them will be action, some of them won't. We'll end up with.
Well, they're running out of time to action them.
They are, yeah. We'll end up with some that get action, some that don't, and mapping be at the margins potentially incorrect.
That may be a situation with this code of compliance, is that may have run its course and that's why we haven't seen it
Mm.
potentially. I'm just surmising.
Well, I think that we'll take a view after we've heard from Mr. DeLasia. If he produces a certificate of compliance, well and good.
Mm.
And if he doesn't, well, there might be questions about why not.
Mm.
And it may be that at the end of the hearing, we ask you to seek Mr. Goldwater's advice as to, on the hypothetical that the outside area is residential and and the SNA uplifted, whether that rectangle, 14-metre rectangle, would retain its significant values so as to be an SNA in its own right, because it'll be sitting on its own. But we'll, as I say, we'll take a view after we've heard from Mr. DeLasia. Just looking at your discussion of the Lincolnshire situation. Over the school site, so this is 113, 114, 115. The other possibility that occurred to me is that Ministry of Education in their infinite wisdom may decide they don't need or want a school on the site, in which case it'll revert to residentially zoned land, in which case the logic you've applied is that it should come off in that event as well.
Yeah.
We talked about the confidence that, you know, the current trends of increased biodiversity will continue. The devil's advocate might suggest that, and this is a point that Commissioner Dash has made in different contexts, that until now, because they are generally steep, difficult sites and did not have the benefit of favourable MDRS standards,
Mm.
that there were, for a long time, there's been some pretty formidable issues developing that urban bush on a lot of sites. But now with the MDRS, it's much easier, absent any SNA Indigenous biodiversity hurdles. So there might be an uptake on that ground.
Mm.
Well, in fact, the whole theory of the NPSUD is that zone it and they will come.
Mm.
Break down the door. So is there a risk on that account that we can't sort of like we can't rely on past practice being perpetuated or past readiness being perpetuated because there were other reasons for inaction?
Certainly the planning settings now in a number of the areas where there would be residential SNAs, for argument's sake, are a lot more enabling, enabling 6-story development. I mean, there will be a number and a percentage of people who choose not to utilise that development capacity which has been provided to them through this process, and those sites remain as they are. Some, on the other hand, will choose to remove vegetation and to redevelop. I guess if we were to land in the position where you take up my recommendation not to pursue residential SNAs and you decide not to pursue an outside SNA control, then really what you're hedging on is that rates of regeneration and restoration and the balance of the district, the city, largely in rural and open space zone land and public land with SNAs on it, achieves objective 1 of the NPSIB, that Indigenous biodiversity is maintained so that there's no net loss, and the requirements of clause 1.7 in respect of the different sort of attributes or requirements are met. And I don't think that's outside the realms of possibility. I suspect you'll hear a different view from Forest and Bird when they turn up. But I think it is entirely possible, given the evidence, the trends in the wildlands report about the current state of Indigenous vegetation and some pretty substantial increases in areas like Makara and Karori, maybe trends not so much in Kaiwharawhara. But I think it is entirely possible that we will achieve objective 1 in absence of outside SNA controls and residential SNAs.
And again, the devil's advocate would say, effectively, we're applying a well-polished crystal ball. We can't really know, and should we apply a precautionary approach, which is what the so are we facing a risk of significant adverse effects so as to give an entree to the precautionary approach? I suppose we don't know that either.
No, we don't.
So
perhaps then that speaks to the value of Section 35 plan monitoring and study environment monitoring and reporting, and a recommendation that that be undertaken at a regular basis.
that's all I had. Mr. Dace, did you have anything else on Mr. McCutcheon's rebuttal?
Nothing additional. I think you've covered the aspects that I wanted to cover. Okay.
Well, in that case, thank you for your heroic effort, Mr. McCutcheon. Very complex set of circumstances and high quality analysis. That doesn't mean we agree with you, but certainly a high quality analysis. And we're grateful for it.
Thank you.
So on that note, adjourned until 9 a.m. tomorrow.
Can I just, there's one point that arose out of some comments this morning that I thought I went away and had a quick read, and I thought I might just draw to your attention
Yep, okay.
because you'll have an opportunity to ask Ms. Dewar about it. It's to do with the Weil legal submissions.
Yep.
And this morning, I think it was you, Mr. Chair, were talking about the definition of habitat and built structures, the role of built structures within that habitat.
Yes.
Now, I went back and checked it because, as I thought it did, what it says is that habitat, it explains what it means, and then it says, but it does not include built structures or an area or environment where an organism is present only fleetingly. So, and I think Melinda Friend's submissions do then go on to basically say built structures are therefore excluded. But it's only built structures where an organism is only fleetingly present that are excluded. A built structure where it's there more than fleetingly is still within the definition of habitat. So the question for you will be, what does the evidence show about the fleetingness or otherwise of the relevant organism, as opposed to whether the structures themselves are built or natural?
That's an interesting interpretation issue
Mm.
about that. Where an organism is present only fleetingly, whether that applies to both the words immediately before it or built structures. But for it to apply to only the latter, you'd expect a comma after the first after structures. That you'd have to punctuate it to have that effect. I think.
Well, yeah, I think
that's the question I will ask Ms. Dewar.
yeah, that is the question. Yeah,
for her.
Does the fleetingness of the organism's presence apply just to environment? I suppose it could be all three, or to area or environment, or to built structures or area or environment.
I don't think it can be just environment, because then it would have to say or an environment.
Yes.
So yeah, I think there are only two options there, but that's quite an interesting question. The definition of habitat.
It may be that is something that's explained a bit more in the 32 or the regulatory impact statement. I don't know.
The counter argument is that if the fleetingness applies to built structures, the reference to built structures is not required at all, because the built structure is necessarily an area or environment.
Possibly. I know of lots of situations where animals use a built structure more than fleetingly, which I think the NPSI, taking a purposive approach to the NPSIB would be intended to be captured. I'm thinking of abandoned built structures in particular, where
Well, you think of birds building nests and roofs.
mm, mm,
Specifically for,
it's something that I'm sure my learned friend will be able to help you on, and I can have another look at it.
Well, as I say, like I come up with about 3 different lines of argument in my mind, and I'm no idea which is the correct one at the moment. While we've been discussing it, so we'll have a chat to Ms. Dewar about that. Is there anything else you want to add, Mr. Whittington?
I just wanted to say that that's probably not the right phrase for it, but the council's happy to abide your views, your position on the late provision of Forest and Birds statement, legal submissions. We can reply to that through Mr. McCutcheon's right of reply, and I can contribute to that, provide some further submissions.
Like the point has occurred to me that if there's any prejudice, it's to Forest and Birds, since they won't know your views until reply, when the only thing they can do about them is appeal.
That's right. That's right, and to yourselves, of course, but that's a matter for you.
That thought has certainly occurred to me.
Mm.
That's what I will probably be discussing with Mr. Anderson, about how unhelpful the position he's taken is. But we will see what we will see. But thank you for that formal advice of your position. So we will adjourn to, as I say, the panel's plan is now to undertake a site visit to Lyle Bay and to Mile Point Beach, and then we will see what we will see. Back at 9 AM tomorrow.